Nationwide news. Three-judge Supreme Court. PNP overturned state of emergency in Jamaica.
Pettigrew Collins and Simone Wolfe-Rees found that the general high levels of crime cited as justification by the security forces and relied upon by the Holness administration did not meet the constitutional standard. It's the latest in a string of court defeats for the Holness-led government. Ricardo Brooks has been reading the 44-page document.
In 2017, more than 1,600 Jamaicans were murdered. St. James alone accounted for 335 of those murders. It was one of the highest murder tallies in any parish in decades. The situation caused widespread alarm and resulted in calls for action. On January 18, 2018, Prime Minister Andrew Holness advised the country that the Governor-General had declared a state of public emergency across the parish. At the time, Holness indicated that the security forces had advised him that crime in the parish was of such a nature and so extensive in scale that it warranted the declaration. On Friday, the judges of the Constitutional Court threw cold water on that security advice. In their judgment, no emergency existed within the meaning of the Jamaican Constitution. In dismissing evidence provided to the court by Deputy Commissioner of Police Clifford Blake, the judges reasoned that the senior crime fighter had not identified the person or bodies of persons who had taken action to warrant the imposition of a state of emergency. The judges say DCP Blake only described, in general terms, the high crime rate in various areas. Despite the government's argument that the Governor-General declared the states of emergency to secure the essentials of life in the affected communities, the three learned judges declared that there was no evidence of that. According to the judges, the fact that there was a sharp decline in murders and shootings during the period of a state of emergency is not within the spirit of the requirement of the Constitution. The judges reasoned that an argument of the ends justified the means was not persuasive. In a particularly surprising part of the judgment, it also appears the judges believe the normalization of a high crime rate in Jamaica means it can no longer be considered an emergency. According to their reasoning, there is logic and good sense in the assertion that a state of affairs which persists over a period of years cannot properly be described as an emergency. They determine that under the Constitution, an emergency is something sudden or unexpected that negatively impacts an entire community. They say in order for the declaration to be valid, the Governor-General must be satisfied that the action is sudden and on so extensive a scale that it is likely to endanger public safety. The judges say the action must have already been taken or is immediately threatened. They say a state of emergency as intended by the Constitution would be justified if a war was imminent, there was an earthquake or hurricane, or if the country's democratic institutions were threatened by subversion. Criminologists have repeatedly pointed out that the country's murder rate is in fact equivalent to countries that are at war. The judges argued that the persisting problem of murders in areas such as St. James is evidence that the declaration of the states of emergency has not achieved the goal of containing serious criminal activities in the areas it was imposed. This, they say, proves the declarations were not demonstrably justified or proportionate. Finally, the judges found that the declaration of new states of emergency, days after the expiration of another, was an attempt by the government to circumvent the constitutional provisions and process.
Of the government,
the declarations were declared void.
I don't want to say they can now sue the government,
Constitution.
but
Ricardo Brooks for Nationwide News.
Meanwhile, the Holness administration says it will continue to view the high level of murders in the country as a national emergency. It made the statement while declaring it will appeal the ruling of the Constitutional Court. In a statement on Friday, the Attorney General indicated that the legal and constitutional implications of the ruling were being reviewed for the appeal. The statement says the administration will continue to support the security forces amid a historic reduction in crime. The government points to effective crime-fighting strategies, historic investment, an increase in the number of police personnel, enhanced intelligence operations, and states of emergency as the causes for the reductions in crime now being recorded. The Holness administration says the imposition of states of emergency resulted in the reduction of murders and saved lives. The administration says it remains committed to the fight against crime and maintaining public safety while respecting the rule of the law.
And opposition leader Mark Golding has welcomed Friday's ruling as a victory for the rule of law in Jamaica. Mr. Golding says the ruling vindicates the PNP's position.
Today's landmark ruling by the Supreme Court of Jamaica is a resounding victory for the Constitution, for the rule of law, and for the people of Jamaica. The court has affirmed what the PNP has long argued, that the multiple and extended use of states of emergency as a routine crime-fighting tool is a violation of the Constitution's extraordinary emergency powers.
According to the opposition leader, there is now sufficient evidence that there can be a reduction in crime and murders without relying on emergency powers.
It is significant that recent statistics reveal a marked decline in murder rates, which has been accomplished by targeted law enforcement measures without recurring states of emergency. Jamaica's long-term security hinges on appropriate policing strategies, robust democratic institutions, and community-led solutions, all achievable without unconstitutional violations of fundamental rights and freedoms.
Mark Golding, opposition leader.